U.S. Education Supreme Court decisions. Supreme Court decisions regarding education have the potential to change the educational landscape for students and teachers across the country. Read on for case summaries and analyses of 10 influential cases from the past century. Famous U.S. educational court cases. The history of the American education system has been shaped by court cases, the outcomes of which have delineated what is and is not acceptable in a school. These cases are sometimes called landmark cases. What is a landmark case? The term refers to judicial decisions that are particularly historic or influential. Some of the most famous and significant American court cases in history have had a focus on education. Some deal with students' rights, some with teachers' rights and obligations, and some with what schools can and cannot enforce. These education Supreme Court cases still impact the experiences of students across the country today, though students may not be aware of it. In the future, there will likely be other very important court cases that further change what education looks like in the United States. What are educational court cases? Educational court cases are any legal cases that deal with aspects of the educational system. These cases can be local or regional, meaning that they only impact a subset of schools, or they can be nationwide. The most important of these legal battles are the Supreme Court cases involving education. Supreme Court decisions are legal judgments made at the highest level of the American judicial system. Relatively few cases are judged by the Supreme Court each year, and there is no higher court of appeals that can challenge the Supreme Court's decisions. Cases are often heard by the Supreme Court when they have gone through a process of appeal in multiple lower courts, but at least one party is still dissatisfied with the result. These cases often deal with individuals' fundamental rights, including rights that pertain to education. The Supreme Court has been called upon on several occasions to determine what rights students do and do not have in an educational setting, which is an important topic that impacts students of all ages on a daily basis. The rights of students have changed over time. Court cases about education. These landmark Supreme Court cases and local cases were all focused on education. In many instances, the premises and outcomes of these cases have been highly controversial, and some remain controversial today. The cases are discussed in greater detail below. Case, date, judgment. The State of Tennessee v. John Thomas Scopes, 1925. The ban on teaching evolution in Tennessee schools is upheld, the defendant is guilty. West Virginia Board of Education v. Barnett, 1943. Compelling students to salute the flag in schools is a violation of their constitutional rights. Brown v. Board of Education, 1954. Racial segregation of children in public schools is unconstitutional. Engel v. Watali, 1962. The state cannot hold prayers in public schools, even if the prayers are non-denominational and participation is optional. Tinker v. Des Moines, 1969. Prohibition of symbolic protest in schools is a violation of students' right to free speech. Lemon v. Kurtzman, 1971. State funding for non-public, non-secular schools is unconstitutional. Board of Education v. Rowley, 1982. Schools are required to provide educational accesses for disabled students but are not required to facilitate students reaching their full potential. Bethel School District v. Fraser, 1986. Public school officials can prohibit student speech that is vulgar, lewd, or offensive, even if it is not explicit. Hazelwood v. Kumaya, 1988. Schools have the right to censor student journalism if they have a compelling reason to do so. Moss v. Frederick, 2007. Schools do not violate students' rights by preventing them from promoting illegal drug use on or near school property. Some of these decisions might seem self-evident today, while others might be surprising. The background to all of these cases and the details surrounding the court's decisions are detailed below. The State of Tennessee v. John Thomas Scopes, 1925. In 1925, it was illegal for any teacher to teach the theory of evolution in the state of Tennessee. This case was actually essentially a publicity stunt to put the town of Dayton, Tennessee on the map. With the assistance of the American Civil Liberties Union, ACLU, several citizens asked a high school teacher named John Scopes to admit to teaching evolution so that they could have the case brought to court. Scopes accepted evolution, but he was actually a physics and math teacher who was not sure if his teaching had ever specifically relied on evolutionary principles. Nonetheless, he agreed, and the case became a highly publicized trial. Because of the controversial nature of the trial, the courthouse was packed with spectators. The defense aimed to establish that evolutionary theory was scientifically valid and should therefore be a part of school curricula. They further argued that the ban on teaching evolution promoted fundamentalist Christianity and was therefore a violation of the separation of church and state. Scopes was found guilty and was fined $100. The ban on teaching evolution remained in place. The law was not repealed until 1967. While this case summary ends with the status quo of the time being upheld, it was hugely influential on later debates about teaching evolution in schools. The events of the trial were dramatized in the 1960 film Inherit the Wind, and, although Scopes was found guilty, many people noted the eloquence and convincing arguments made by his defense team. Today, the trial is often called the Scopes monkey trial. This is because the anti-evolution law was concerned with the implications of teaching that humans had evolved from lower orders of animals, and comparisons between humans and other primates were an important part of the discussion. West Virginia Board of Education v. Barnett, 1943. West Virginia Board of Education v. Barnett was another court case with a controversial subject. In 1942, the West Virginia Board of Education made it mandatory for students at public schools to salute the American flag as part of regular school activities. Students were also required to say the Pledge of Allegiance as a show of patriotism and respect. Failure to salute the flag was officially regarded as an act of insubordination and could lead to expulsion. The religious doctrine of Jehovah's Witnesses forbids members of the faith from saluting or otherwise pledging allegiance to any symbols or images, because of a particular reading of Exodus 20, 4-5, which says, in part, "Thou shalt not make unto thee any graven image, or any likeness of anything that is in heaven above, or that is in the earth beneath, or that is in the water under the earth. Thou shalt not bow down thyself to them, nor serve them, for I the Lord thy God am a jealous God." KJV. As such, some Jehovah's Witness children refused to salute the flag and say the Pledge of Allegiance, sometimes resulting in their expulsion and even their parents' arrest. School and state officials sometimes threatened to send these children to reformatories for juvenile delinquents. This particular case revolved around Mary and Gaddy Barnett, two Jehovah's Witnesses who were expelled for refusing to salute the flag or pledge allegiance. Their parents brought a lawsuit to the United States District Court and, unlike all previous cases on the issue, they won. The school district appealed, and the case ended up going to the Supreme Court. The court ruled that it was unconstitutional for public schools to compel students to salute the flag. This judgment remains in place today. Brown v. Board of Education, 1954. Brown v. Board of Education is one of the most famous legal battles in American history, exceeded in its ubiquity in the public consciousness perhaps only by Roe v. Wade. The full title of the case was Brown v. Board of Education of Topeka, and it was a case that changed access to education forever. In 1896, the Supreme Court ruled that it was legal for public schools and other public facilities to be racially segregated, provided the facilities were of equal quality. This was known as the separate but equal doctrine, but is more commonly known today as the Jim Crow laws that barred black Americans from accessing the same services as white Americans. This also applied to education, and, as many people are aware, the equal part of the separate but equal doctrine often failed to hold up in practice, regardless of what the law said. In 1951, a black man named Oliver Brown filed a lawsuit against the Board of Education of Topeka, Kansas. His young daughter had been denied entry into an all-white elementary school. Brown argued that education for black children was not equal to that of white children and that this inequality was unconstitutional, violating the Equal Protection Clause of the 14th Amendment. Although the court agreed that segregation had a detrimental effect on children of color, it refused to change the law. In 1952, the case came before the Supreme Court, along with several other lawsuits making the same argument as Brown. The decision was not issued until 1954, but when it was delivered, it made history. The Supreme Court ruled that segregated schools were inherently unequal and that school segregation was unconstitutional. While the ruling was very important, it was also vague. Some school districts awaited the change in laws and many black students attending formerly segregated schools faced violence and racism. This continued discrimination was most clearly visible in the case of the Little Rock Nine, who were 9 black students in Little Rock, Arkansas, whose fight to enter a previously all-white school resulted in federal troops and the National Guard having a standoff that ended with the students entering the school under armed guard. Engel v. Watali, 1962. The Engel v. Watali case concerned religion in schools. Prior to this case, a New York state law made it obligatory for public school classes to begin each day with both the Pledge of Allegiance and a non-denominational prayer. The law did not make participation mandatory for students who objected to it. In practice, some schools may have made it challenging for students to opt out, and those who chose to do so may have been met with suspicion. A parent sued the state on behalf of his child, arguing that even though the prayer was not mandatory, it was still a violation of the Establishment Clause of the First Amendment. In other words, it was a violation of the separation of church and state. Other groups joined him in his protest. The New York Court of Appeals rejected the suit and upheld the law that required a non-denominational prayer. The case went to the Supreme Court, which ruled that the state cannot hold prayers in public schools. They ruled that mandating them was unconstitutional, even if students were not required to participate and even if the prayers were not connected to a specific religion or denomination. The case was ruled on the basis of the separation of church and state. A dissenting justice argued that the prayer should have been allowed because it did not establish an official religion, but his argument was overruled. Tinker v. Des Moines, 1969. Tinker v. Des Moines was a court case that dealt specifically with the rights of students in the classroom. When it comes to the rights of students, schools are often put in a difficult position. On the one hand, they have to uphold their students' constitutional rights, but on the other hand, they are a public institution charged with the care of minors and must have certain boundaries in place to ensure the safety and well-being of students and staff during school hours. In 1965, several students from the Des Moines Independent Community School District organized a protest to show their support of a truce in the Vietnam War. They elected to wear black armbands to school for several weeks. Their school learned about their protest a few days before it began and immediately implemented a policy that any students wearing armbands would remove them or face suspension. Several of the students wore their armbands anyway and were sent home as a result. The students sued the school district on the basis that the school was violating their right to self-expression. The district court found in favor of the schools, as did the U.S. Court of Appeals for the Eighth Circuit. When the case made its way to the Supreme Court, the justices took a different view. They ruled that the armbands were an acceptable form of protest and that students retained their rights to free speech while on school property. If the school wanted to suppress their speech and actions, they would need to prove that the students' actions would, materially and substantially interfere, with the school's educational mission. The judges specified that students were not necessarily guaranteed the full extent of their First Amendment rights during school time, but that a non-disruptive form of self-expression like the armbands was acceptable. Lemon v. Kurtzman, 1971. The Lemon v. Kurtzman case is one of the more intricate and potentially challenging cases on this list. That is because this case dealt with the intricacies of the Establishment Clause of the First Amendment. The case began after Pennsylvania and Rhode Island began providing state pay for secular aspects of religious and private education. The state provided these schools with subsidies to pay for textbooks and other materials, as well as supplements to teachers' salaries. Some Pennsylvania citizens brought the case to court, arguing that such funding, which came from taxpayers, was in violation of the separation of church and state because it used taxpayer money to partially fund religious institutions. One of the citizens who brought the case forward was named Alton Lemon. To determine if the states were in violation of the Establishment Clause, the Supreme Court applied what is now known as the Lemon Test. This test was a way of verifying if a law violated the Establishment Clause by seeing if it failed to live up to any one of 3 attributes. The statute must have a secular legislative purpose. The primary effect of the statute must neither advance nor inhibit religion. The statute must not result in excessive government entanglement with religion. The court ruled that while Pennsylvania and Rhode Island's funding of religious and private schools was not in violation of the first two elements of the test, it did violate the third one. This was because, in order to ensure that the funding was used for exclusively secular purposes, the government would have to get too involved with the schools in their use of funding. The court ruled that state funding for non-public, non-secular schools was in violation of the Establishment Clause. Board of Education v. Rowley, 1982. This is one of the most famous special education court cases in American history. It focused on the interpretation of the 1975 Education for All Handicapped Children Act. Specifically, the case was about how far schools have to go to accommodate students with disabilities and how those accommodations should be determined. Amy Rowley was a deaf student and her school refused to provide a sign language interpreter for her in the classroom. The school argued that Rowley was doing well in school and that an interpreter was not necessary for her academic success. The Education for All Handicapped Children Act, they said, required schools to provide reasonable access to education that did not necessarily include providing a sign language interpreter. Rowley and her parents argued that while she was doing well in school, she would have been doing much better with an interpreter. Her residual hearing and her lip reading skills allowed her to understand around 60% of class discussions, while an interpreter Her residual hearing and her lip reading skills allowed her to understand around 60% of class discussions, while an interpreter would allow her much greater understanding. The case went through several lower courts before finally making its way to the Supreme Court. The Supreme Court ruled that the existing legislation did not require the school to provide a sign language interpreter as long as Rowley had adequate access to education. They argued that schools were not required to provide accommodations that allowed disabled students to reach their full potential, as such a requirement would be difficult to establish and maintain. The school was not required to, and subsequently did not, provide an interpreter. It is worth noting that this ruling applied specifically to deaf students requesting interpreters and was not necessarily a broadly applicable ruling for all instances of disabled students' accesses. Bethel School District v. Fraser, 1986. Bethel School District v. Fraser was another case dealing with students' rights to expression in schools. Unlike the Tinker v. Des Moines case, this one found against the student and affirmed schools' rights to curtail student expression under some circumstances. In 1983, a high school student named Matthew Fraser gave a speech at his school nominating his classmate for Associated Student Body vice president. The speech, while not explicit, was full of sexual innuendo as a way to appeal to students' sense of humor and irreverence and improve Fraser's classmates' chances in the election. Fraser was suspended for delivering the speech, the text of which was, "I know a man who is rock hard, he's firm in his pants, he's firm in his shirt, his character is firm, but most of all, his belief in you the students of Bethel, is firm. Jeff Kuhlman is a man who takes his point and pounds it in. If necessary, he'll take an issue and nail it to the wall. He doesn't attack things in spurts, he drives hard, pushing and pushing until finally, he succeeds. Jeff is a man who will go to the very end, even the climax, for each and every one of you. So please vote for Jeff Kuhlman, as he'll never come between us and the best our school can be." In addition to his suspension, Fraser was forbidden from speaking at his graduation ceremony later that year. The ACLU helped Fraser file a lawsuit arguing that the school had violated his right to free speech. The United States District Court and the U.S. Ninth Circuit Court of Appeals both ruled in Fraser's favor. The case was brought before the Supreme Court, where the decision was overturned. The Supreme Court ruled that the school had not violated Fraser's First Amendment rights. The judges explicitly contrasted this case with Tinker v. Des Moines, arguing that while students retain the right to express themselves in a non-descriptive way, they did not have the right to sexually vulgar styles of expression. Hazelwood v. Cumaya, 1988. Hazelwood v. Cumaya was another case dealing with students' right to free expression in schools. This case was about whether or not it is acceptable for schools to censor articles in student newspapers if they believe that those articles are inappropriate. Several students in a journalism class who wrote and edited a paper called The Spectrum were at the heart of this case. The students, including editor Kathy Kumair and reporters Leslie Smart and Leanne Tippett, wrote for a paper that was sponsored and funded by their school. They wrote articles about their classmate experiences with teen pregnancy, as well as an article on the impact of divorce on children and adolescents. Before the paper was published, school officials removed both stories without informing the student journalists. The students claimed that the school was infringing on their First Amendment rights by preventing them from writing about issues that were important to them. The U.S. District Court for the Eastern District of Missouri in St. Louis ruled that the school did have the authority to remove articles that were written as part of a journalism class. The students appealed, and the U.S. Court of Appeals for the Eighth Circuit reversed the verdict, finding in the students' favor by arguing that the paper was a public forum in which censorship would only be acceptable under extreme circumstances. The school then appealed to the Supreme Court, where the decision was once again reversed. The court ruled that because the paper was sponsored by the school, and because the school had a duty toward its students when it came to which content it exposed them to, the school had the right to censor articles. The court argued that the paper was not a public forum and that schools in general could censor written student expression provided the censorship was reasonably related to legitimate pedagogical concerns. Moss v. Frederick 2007. Moss v. Frederick was one of the more recent education court cases that made it to the Supreme Court. Once again, it was a case that sought to determine what rights to expression students hold in the school system. As with some other cases, the Supreme Court ruled against the students, establishing limitations to their rights. In 2002, an Olympic torch relay went through Juneau, Alaska. Joseph Frederick, a high school senior, attended the relay as part of a school-supervised activity that took place across the street from school property. At the rally, Frederick held up a banner that read, "Bong hits for Jesus." He was told to put the banner away, but he refused. He was suspended on the grounds that his sign could be read as advocating for the use of illegal drugs. The U.S. District Court ruled in favor of the school when Frederick took the case to court, but the U.S. Court of Appeals for the Ninth Circuit reversed the ruling and said that the banner was actually constitutionally protected speech. The Supreme Court agreed to hear the case and ended up reversing the judgment again, finding with the school administrators. They ruled that administrators may suppress student expression if it is reasonably viewed as promoting illegal drug use. This case also referenced Tinker v. Des Moines, pointing out that student protest or political speech could be prohibited if it was substantially disruptive to the educational process. While the language of this ruling is narrow, referring only to student expression pertaining to illegal drug use, some critics expressed concern that it could be interpreted more broadly and could allow schools to erode students' rights to free speech. Despite these criticisms, the ruling remains in place today. Why educational court cases are important. Understanding the history of educational court cases is important for students, teachers, and also anyone else interested in American history and the ways that rights and obligations are expressed in codified law. The path to becoming a certified teacher involves significant education and a range of examinations. The specific tests and requirements vary by state, and can include the Praxis exam, CSET and CBEST, Texas test, or more. Some of this preparation, both national and local, will help new teachers understand their rights and obligations in the classroom. Teachers work hard to provide a safe and productive learning environment for students, and knowing the history of education and the law in the United States can help teachers appreciate their field's background while also raising awareness of what precedents exist to codify what is and is not acceptable in an educational environment. Knowing about these cases can have real-world consequences. Teachers who are unaware of their students' rights can be either too permissive with unacceptable behavior or can accidentally violate their students' rights as established by previous cases. Similarly, a familiarity with these cases can help teachers defend their students' rights and their own rights when necessary. Teachers, students, parents, and school administrators can approach gray areas and challenging incidents that might arise in schools with the knowledge of previous examples of such cases. They can also learn from previous cases to learn what the process is for seeking legal action if they should ever find themselves in a similarly difficult situation. Laws are mutable concepts that impact everyone but that also change and adapt to circumstances over time. Understanding how education and the law interact can benefit students and teachers alike.